Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Today we're going to discuss an important case settled by the U.S. Supreme Court in 2007. The case was called Massachusetts versus the Environmental Protection Agency. The EPA had been asked to begin regulating emission of 4 greenhouse gases, including carbon dioxide. The EPA responded by asserting that the Clean Air Act did not authorize the EPA to issue mandatory regulations to address global climate change. I will be discussing this case with Douglas Williams, Professor of Law at St. Louis University School of Law. Professor Williams teaches and writes in the areas of environmental law, natural resources, administrative law, constitutional law, and professional responsibility and ethics. Professor Williams, welcome to Conversation.
Thanks for inviting me.
So, it's an interesting case. I imagine since you teach environmental law, this might be one of those cases that you actually talk about in your classes.
Oh yes, very much so. It's
so why don't you give us this, as they say in law, the syllabus here.
Okay. As you mentioned, in 1999, EPA was faced with a petition by a number of environmental organizations and a coalition of states who were dissatisfied with the pace of the federal response to global climate change. So they petitioned EPA to promulgate rules that would control greenhouse gas emissions from new motor vehicles. The petition sat before EPA for a number of years with no response. Ultimately, EPA denied the petition for rulemaking, which in essence is saying we're not going to regulate emissions from new motor vehicles. And the reasons it gave were some technical ones and then some more policy-driven reasons. The technical reason that EPA declined to engage in the rulemaking was that it interpreted the Clean Air Act to regulate certain kinds of pollutants, but believed that carbon dioxide and the other greenhouse gases that were included in the petition did not constitute air pollutants within the meaning of the Clean Air Act. As a consequence, the agency believed it lacked the authority to issue the regulations requested. The more policy-driven reasons that the agency offered had to do with how the Clean Air Act would actually function as a means of regulating greenhouse gases. The agency believed that using the Clean Air Act would constitute a more piecemeal approach than the kinds of comprehensive approaches that would lead to an effective response to greenhouse gas emissions. It also was concerned that regulating through the Clean Air Act might interfere with the Department of Transportation's development of what are known as corporate average fuel economy standards, which are, the miles per gallon that manufacturers are required to meet on average for their fleets that they market in the United States. So that was one policy-driven reason. The other one was fear that regulation through the Clean Air Act might interfere with international efforts to reach a consensus on how best to address the problem of global climate change and what sorts of regulation might be appropriate as a response.
Okay, so now the EPA Administrator, this issue, from what I heard you say and from reading of the case and other issues, this is actually all about emissions of motor vehicles.
Right.
That was the narrow issue, emissions of motor vehicles, which Congress gave to the EPA to regulate what comes out of the tailpipe of motor vehicles.
Right.
Right. Also, Congress gave to the EPA Administrator a certain amount of discretion in acting as to whether or not they will or will not act in certain areas. That's it. And so this, you say, starting in 1999, which would be during the Clinton administration.
Right, the tail end of the Clinton administration.
Right, well, 2 more years, 99 and 2000. that administrator then declined to use discretion to get into this at that time anyways.
Well, there is a process involved here. When the EPA issued what is known as a public notice of proposed rulemaking, in which it solicited comments from regulated entities and the general public about the merits of the petition that was before it.
Is this when they got the 50,000 comments, or was that later on?
Right. That they did get
50,000 people comment, or entities
a large
commented.
number of comments, right, on this particular issue. So it's a very public sort of process that takes a little bit of time. The agency typically, when it receives one of these petitions, sometimes it may summarily deny it, but if it believes that it raises important issues, it will begin a sort of public process of the type I've described. And that takes an enormous amount of time in some cases, because new information will come to the agency's attention during the comment period. They'll have to develop effective responses to that and so on. But in terms of the actual petition, I think it's important to stress that this was a pretty strategic move on the part of the states and the environmental organizations. I think it's important to recognize that the effects of granting the petition by EPA, if it had chosen to go that route initially, would have triggered a number of other obligations under the Clean Air Act, not necessarily limited to just regulating new motor vehicles. There's kind of a cross-fertilization process in the Clean Air Act. So if EPA had found initially, for example, the greenhouse gas emissions from motor vehicles constitute a substantial risk to public health, that finding would transfer over to other programs within the Clean Air Act that regulate stationary sources like industrial plants, power plants.
Like where we get our electricity from.
Precisely. So this was kind of, I would style it as kind of an opening wedge for the environmental organizations in the states in a larger campaign to get EPA to utilize the regulatory powers that had been delegated to it under the Clean Air Act by Congress. The other piece of the strategy here, I think, was a political strategy. Forcing the EPA to take action under the Clean Air Act might prompt Congress and the administration to consider whether that would be in the best interest or would that be the best approach to regulating greenhouse gases. And if EPA were going to move forward with regulation under the Clean Air Act, it might prompt Congress to respond with a more comprehensive kind of approach to regulating greenhouse gas emissions that probably would yield an overall more beneficial program. Of course, as we know, the politics were such that that didn't play out that way. But I think that sort of strategy might have been clearly in the minds of the court when it received these petitions.
But what was in the mind of Congress when they were writing the original laws? I guess is that not the job of the Supreme Court, is to interpret what's in the mind of the lawmakers who put the rule structures together?
Yes, I think that is the function of the court. It's not so much to get into the minds of the individual congressman, but to discern what we might describe as the purposes or intents of the legislation that they enact. And the Clean Air Act is a very broadly worded statute. It defines pollutants to include, chemicals, chemical agents that have physical properties when emitted into the atmosphere may produce air pollution that the administrator might determine to be an endangerment to public health. So it's a very broadly worded statute. The language of the statute also makes reference to public welfare, protecting public welfare. And interestingly enough,
isn't that the language you're referring to, though? That's not in the original 1970 Clean Air Act. That was the Muskie Act. I believe that was an amendment from '97.
Well, no, that provision is actually a part of the initial 1970 Act. It was modified very slightly in response to some challenges in court about whether EPA could regulate in a very precautionary way. So the only major change to that particular provision was the addition of language may endanger rather than the previous version which said endangers. And the suggestion behind that amendment was that EPA should have discretion to regulate in a precautionary way. We don't have to wait for complete scientific certainty before we choose to regulate activities that may pose hazards to public health and welfare. But back on the welfare point, one sort of clue about what Congress was thinking about in 1970 and in 1977 when it amended the Act, the definition of welfare actually included a reference to pollutants that might induce changes in climate. At that particular time, climate change was a science in its infancy. There had very little understanding about atmospheric processes and the potential for significant global climate change associated with emissions of greenhouse gases, but it was on the radar. It was something that many scientists had sounded an alarm about. And so many congressmen knew that this issue was lurking back there. Whether they intended the Clean Air Act to actually address that problem is another whole kettle of fish. But, like I say, the language of the statute is broad enough to potentially include regulation of greenhouse gases. When the Supreme Court was reviewing a decision, but the District of Columbia Circuit was the first court who received a challenge to EPA's denial of the petition.
Go over that just a little bit so people understand what exactly happened here. There was a group of plaintiffs who came before the EPA,
right,
asking them to do, so you're the lawyer, you tell people what happened here.
The way this whole thing got started was, as we mentioned, a petition was filed with the EPA to undertake a rulemaking to regulate these greenhouse gas emissions from new motor vehicles. EPA denied that petition. While the Clean Air Act has provisions in it that allow persons who are adversely affected by agency decisions to seek review of those decisions in appropriate courts. In this case, the court that would be designated as the appropriate court to review challenges to EPA's denial was the United States Court of Appeals for the District of Columbia Circuit. So they entertained a challenge to the petition. They ultimately sustained EPA's position without taking a clear position on whether carbon dioxide and the other greenhouse gases constituted air pollutants within the meaning of the Clean Air Act. The DC Circuit accepted EPA's alternative, more policy-driven reasons for choosing not to regulate. Okay, and it's an interesting sort of posture. If you think about ordinary challenges in the regulatory context, they typically come from parties who are subject to regulation and are challenging actions that the agency has taken that would result in regulation.
But not usually states.
And not usually states. But the more sort of interesting aspect here is how the law responds to an agency's failure to act rather than its taking action that might affect the pocketbooks or financing of regulated industries. So it's a kind of interesting contrast to the ordinary regulatory case. And it's made more complex because when courts do review agencies' failure to act, there might be a whole host of reasons why an agency chooses not to act. They might be very sort of practical reasons like lack of budget. They might have other priorities that are consuming the agency's time. So a challenge of that sort is a little bit more difficult to mount than a challenge to agency decision to regulate.
So the case before the Supreme Court wound up being not necessarily the merits of global warming, but whether or not the EPA had discretion as to whether to make this rule or not.
Right.
And that's the whole, and also whether the parties had standing to come before the court.
Right. The standing question is a very interesting and complex one. This is an area of constitutional law.
Encapsulate that.
Yeah, this is an area of constitutional law that has baffled not only parties before the courts, but people like me who tend to make a study of these things. Standing relates to the question of who is the proper party to challenge action by another party.
Yeah, explain that not anybody can go to court.
Right.
You have to be the one who's being hurt.
Right. The Constitution established a judicial system that serves fairly discrete functions. In terms of Article 3 of the Constitution, that function is described as deciding cases and controversies. So the court doesn't stand as a general body who can entertain all sorts of questions. Rather, it is an entity that is designed to serve the limited function of solving real disputes among real parties. Okay. If we wanted the court to serve a more broad function, like give advisory opinions to politicians and so on, we might have expected the framers to designate such a role.
I believe the court made that decision in 1897, didn't they? That they weren't in the advisory business.
That's exactly right. President Washington had asked the court for an opinion about certain foreign affairs matters. The court politely but sternly said, "I'm sorry, that's not our business. We're in the business of deciding disputes among parties over real legal issues. We are not in the business of giving legal advice to the political branches." So out of this sort of notion that the courts serve a more limited and discrete sort of function, the court has developed a fairly elaborate system of deciding when a particular dispute constitutes a case for purposes of Article 3. And if it does, of course, the court can decide that matter. If not, then the court would determine that Article 3's powers that are conferred upon the court do not extend to the dispute that the parties are bringing before the court. And one of the elements here is, of course, the element of standing that you introduced here. Over the years, the court has determined that in order to bring a case in the Article 3 sense, the party seeking review by the court must allege that they have been personally injured by the action they are challenging.
And what did Massachusetts assert in all this, since they were the named party?
Yeah, it's an interesting thing. Massachusetts claimed that there were actual effects of climate change that had already injured the state. Some sea level rise, excuse me,
And both damage of us today with the voice.
Damage to some coastal resources, and more concretely, or probably less concretely actually, the prospects of future harm to the state were the ones that Massachusetts was really concerned about. And those, of course, would be sea level rise, loss of low-lying coastal areas, the need to update and perhaps replace damaged infrastructure as a result of...
They made a claim that that there was over the 20th century, a 10 to 20 centimeter rise in the level of the oceans, and that they had suffered, was it several $100 million worth of
Yes.
damage, which would need to be remediated.
Right, right.
And that's what gave them, or at least that's what they claimed gave them standing, but that was to be decided.
Right. The court accepted that characterization of why they were bringing the claim and accepted that as a injury sufficient to support their standing. Where the court, I should say, divided on the standing question. There was a dissenting opinion by the Chief Justice.
I was going to say,
Roberts,
now we come to Roberts,
who believed that none of the parties before the court, Massachusetts or any of the environmental petitioners, had actually established their standing to litigate the case. Roberts himself accepted Massachusetts' characterization of their injury. Where he believed the standing question fell apart for the state was on the question of whether, let me back up. Standing actually requires a showing of three elements by a party seeking the assistance of a court to resolve a dispute. One is this injury component. The other is the injury that the party is alleging has to be fairly traceable to the defendant's conduct. In other words, there has to be some causal linkage between the injury that the plaintiff is alleging and the conduct that they're challenging on the part of the defendant. The final part of the standing issue is the question of whether the relief that the party is seeking from the court is likely to be an effective remedy for the injury that they've alleged.
And this is what Roberts was...
This is where the standing issue fell apart for Roberts. He believed that what Massachusetts was asking EPA to do would have little, if any, effect on global climate change, and hence would not effectively remediate or offer a remedy for any harm that Massachusetts might suffer.
So what he was saying was that, yes, EPA can go ahead and regulate tailpipe emissions all they want, but that's not necessarily going to keep Massachusetts' coast from continued degradation.
Right. He's saying, look, you want us to force EPA to regulate these tailpipe emissions, but what do you get if we do? You might get regulation of greenhouse gas emissions from cars, but in terms of actual effects on global climate change, what are you going to get? Mm-hmm. And Roberts believed that Massachusetts hadn't been able to show that the relief they were requesting would make any discernible difference.
Now, I have to point out that time runs by here so fast. I think we're like at 7 or 8 minutes left here, so I want to make sure we get, it's gone. So I want to make sure that we get through this whole thing. One, it was a very narrow decision, 5-4, with Kennedy going on the side of Stevens, which brought them to the winning majority. I also wanted you to say, okay, since that case was decided, and it was decided that EPA did not have the discretion to say no, and therefore they had to take up this petition, as I understand it.
Well,
what's happened since then?
Okay, let's talk about the actual decision. EPA had offered these various reasons for not regulating. Technically, the court held that EPA erred in holding that these greenhouse gas emissions were not air pollutants. So that reason went out the window. That wasn't an adequate legal justification for not granting the petition. That's point one.
Not according to Scalia.
Yes, Scalia disagreed on that particular point.
Go ahead.
The other reasons that EPA offered, the court held, were not legally relevant decisions, and for that reason could not properly be relied upon by EPA in declining to grant the petitions. Instead, the court says you have to rely on statutorily recognized factors. And in essence, what the court says is this: the statute directs you to make a determination along these lines. And the lines in the statute are, of course, whether the air pollution might give rise to public health problems or problems in public welfare. Well, EPA had nothing to say on that question in its denial of the petition. The court says, this is what you have to do. If you're going to deny this petition, you have to do so on the basis of the statutory factors. So it was a strong signal to EPA that, look, you have to make a determination about whether these greenhouse gas emissions are a public health hazard. So it went back to EPA. The court didn't direct EPA to engage in this rulemaking. It still left it the opportunity to determine for itself whether rulemaking was warranted, but along the lines commanded by the statute. So EPA ultimately did engage the issue and made a finding in 2009, December of 2009, that greenhouse gas emissions from new motor vehicles actually did constitute a risk to public health and welfare. Mm-hmm. That decision, by the way, is currently being challenged in court. We don't have a ruling on that. But after that, EPA then proceeded to engage the rulemaking process, ultimately leading to establishment of new motor vehicle emission standards beginning in 2012. I think the standard is 35 miles per gallon for most cars and light-duty trucks, beginning in 2012.
What about power plants? Where do they come in, or do they come into this decision?
They do, in fact. The finding that greenhouse gas emissions represent a risk to public health, a significant risk to public health, then made greenhouse gases a pollutant regulated under the Clean Air Act. Now, if you look at how stationary sources are regulated under the Act, it's quite complicated, but there are provisions relating to new stationary sources, new construction of stationary sources like power plants. Mm-hmm. And those regulations for new sources also apply to existing sources that are modified in ways that increase the amount of air pollution they emit. So these are known as new source performance standards. And EPA is obligated under the Act, or at least its interpretation of the Act, to establish these new source performance standards for all categories of sources that emit any pollutant that is regulated under the Clean Air Act. So having found that greenhouse gases should be subject to regulation for new motor vehicles, those gases then become a pollutant regulated under the Clean Air Act, which gives rise to the obligation on the part of EPA to establish these new source performance standards for stationary sources.
We got about 3 minutes. I got to ask a question. One, Stephen starts right out at the very top of his opinion with the science is settled. Okay, that's like, I don't know if that's sentence 1 or 2, but he starts right off with that. The question I have for you, not just as a lawyer, but as a citizen, what if the science is not right? And what if we are now pushing industry in America in a direction which the rest of the world is not following necessarily, and increasing our costs and doing damage to our economy? Is that the role of the court, to make those kind of enormous decisions, or should they flip it back to the political people to make a final judgment? Okay, yeah, we hear the greenhouse gases are bad, but we decide in our opinion it's more important for this. Or no, we agree that it has to be taken care of and doesn't matter what the cost is.
Well, I would agree with you. I think that fundamentally this is the role in regulating these emissions should fall upon the political branches, that is Congress and the President. And it's certainly not the court's responsibility to decide what issues are appropriate for regulation. On the other hand, I would disagree a little bit. I don't think Stephen's discussion of greenhouse gas emissions should necessarily give rise to the conclusion that the court would accept no other conclusion from EPA about where the state of the science is. Mm-hmm. But frankly, and I'm no scientist, but I think if we were to turn to the actual scientific literature, there is a general consensus among scientists that, in fact, emissions of greenhouse gases have contributed to increased concentrations of these gases in the atmosphere, which in turn has caused a human-caused increase in global mean temperatures or climate change.
That's about all we got.
Okay. Well, thanks
if you've
much.
got, we'll leave it there. We'll have you back another time. I think this is a very interesting discussion. I thank you very much for being with us. And to my audience, I've been speaking with law professor Doug Williams. He's a professor of law at St. Louis University. To those of you who are regular viewers, see you next Monday.